SCOTUS has been at the center of a couple of controversies over the past week, and you probably have heard of them. It's the DACA ruling and the so-called Bostock ruling, which has to do with what is the meaning of sex discrimination. Well, I wanted to clear up. I wanted to clear up some misconceptions because I've taken a look at the rulings. I took a look at least at the syllabi for the two rulings, and there's a lot less there than meets the eye. The media has been hyping these as big, game-changing decisions, and they just aren't that. The DACA ruling, which is, of course, deferred action for children, as opposed to DAPA, which was the parents of arrival. So DACA, child arrivals, and DAPA for parent arrivals. The ruling was very narrow. What the Supreme Court actually ruled was that the Trump administration had not followed the APA, the Administrative Procedure Act, in removing DACA. Not that they couldn't do it, but that they hadn't followed the APA. Now, so you mentioned this on Twitter. Why can't a president undo the executive order of a previous president? And the answer is they can. And this isn't exactly an executive order. It's called it's called administrative guidance. So to sort of sum it up, the executive branch is responsible for executing the laws. So Congress passes laws, the executive branch puts them into force. The Obama administration says we're not going to enforce the law against these people, which arguably is unconstitutional, but that wasn't the question before the Supreme Court last week. The question...
I would argue strongly that that's unconstitutional, by the way.
Well, executive orders aren't in the Constitution. And does Congress have any say in how their orders are enforced? I would say they do. That's the point of them passing laws, is they're the ones making policy.
Well, the issue that I have there is, for instance, when you talk about law enforcement in general, obviously the executive branch has a lot to do with policy. They have a lot to do with deciding how those laws are going to be enforced, because they determine how those resources are allocated. But that's not what happened in DACA. DACA wasn't a situation where, for instance, the Obama administration made a directive to ICE and said, listen, when it comes to enforcing these immigration laws on people in this particular situation, these children that have been in here for years, we're just not going to focus resources on that. We're not going to focus our resources on that. That is a legit executive role. In principle, that's no different than doing high traffic enforcement versus saying, you know what, we have to put our resources in this, drug-infested, gang-ridden area of town. You know what I mean? So you allocate your resources to where you think the problem is. And then obviously other laws, as a result, are not going to be enforced as strictly because resources are always limited. Right. That, to me, is perfectly permissible. The problem with DACA was that it actually enacted regulations that were contrary to the law and provided a process for people that was not provided for by Congress.
And what's really interesting about that, you're right about that. It was unconstitutional. However, at the time that the Supreme Court ruled on that, there were only 8 justices on the bench because Anton Scalia had just died. So what happened was the Supreme Court deadlocked 4-4, and basically the lower courts ruled on it. Judge Roberts ruled that DACA was implemented unconstitutionally. And he ruled the same way this time, that both actions, both Trump's action and was illegal, and that Obama's action was unconstitutional. But unfortunately, because of the 4-4 deadlock, his ruling had no effect. If it's 4-4, the lower courts make policy, and so in effect, this unconstitutional use of executive power by President Obama was allowed to stand, which is a farce. But it was just timing. It's very unfortunate. Now, here's the thing: the president has said, he said on Twitter, we have to start from square one. Well, that's absolutely right. There is nothing stopping the Trump administration from going through the process of they have to give an official explanation for what they're doing, they have to then have to allow a comment period. And the thinking is this. Are you familiar with the Chevron doctrine, Eric?
I am not.
Okay. The Chevron doctrine says that the executive branch gets the first crack at interpreting the law before the courts do, and that the courts should defer to the executive branch if it's reasonable. And this is essentially part of that. It's been codified by Congress, an official process for allowing the executive branch to say, this is what we think the law means. We're the ones who have to enforce it. So, we have the most stake. The courts can make all kinds of crazy rulings because they don't actually have to worry about, does this ruling make sense? And then they can just throw that mess back to the executive branch. This is a process that allows the executive branch to, in a controlled, structured way, to exert their responsibility to interpret the law before the courts do. So to prevent the courts from just going willy-nilly and making rulings that can't be carried into practice. Does that make sense?
It makes sense. I don't think it's necessarily being followed, but it makes sense.
Yeah. So
because we've seen multiple preemptive actions by courts,
right?
Especially with Trump, when he's issued an executive order, we've seen courts say, "No, you can't do that."
Right.
I don't necessarily believe that doctrine's being followed.
No, but they are supposed to give the utmost deference to the executive branch, but they don't always. The other one is Bostock. A lot of people are losing their minds about this, and I'll follow in our final segment. I'm going to talk a little bit about this, but essentially, in Bostock, they ruled. A lot of people said, "Hey, these are Trump appointees. This is a Trump appointee. Why did he rule against the president? Why did he rule against conservatism?" This is Gorsuch, who wrote the Bostock ruling, and there were 3 cases that were rolled into one. And the one I think is the most straightforward had to do with a transgender woman, a male to female, someone going through that transition, wanted to wear the uniform, their work uniform of a woman at work. And what the courts ruled was to not allow that person to wear a female uniform was sex discrimination. And, if you think about it, that could apply not just to people who are transsexual or transgender, but to any uniform policy. You don't have to declare that you are transitioning or not. It doesn't matter. They were sort of robotically applying the letter of the law that this is sex discrimination. Now, is it pernicious? I mean, I don't think it's pernicious to have a female uniform and a male uniform. If airlines have it for stewardesses or flight attendants, but is it technically discrimination? Well, it technically is. Was that what the original intent of the law was? No, absolutely not. And the question is then, well, what happens the next time they go at say admissions to college, and they say, okay, you have affirmative action, you have race-based admissions, which the courts have ruled against a number of times, and then the schools have kind of reeled it back a little bit and tried to massage it. Oh, we have this different formula for Latino students or Black students or white students. The next time the court rules on this, you now have all of the liberal justices on record endorsing a textualist interpretation of the Civil Rights Act of 1964. So it'll be interesting to see how they unwind that, because it seems to me that they've really painted themselves into a corner on that issue.
It seems just bizarre to me, what's happening sometimes with some of these rulings, because clearly the intent of the anti-discrimination laws had nothing to do with your uniform. I mean, that's something. Women's bodies are different than men's bodies, and there's the military obviously has uniforms for females and uniforms for males.
Right.
A lot of it is fairly unisex. I mean, for instance, wearing a skirt is an option usually for female officers and enlisted folks. It's not something that's generally required unless they're trying to literally be uniform and they all agree and all that kind of stuff.
Right.
But it seems kind of silly to me. So it seems to me what we're headed towards is that everything has to be unisex. And I'm sure that was not the intention of the law. The intention of the law was not that everybody has to have a unisex uniform. Oh God, I hope this does not affect Hooters. Just please don't let it affect Hooters, this ruling, because that's going to be terrible. That's disgusting. So,
well, there was a court case against Hooters about 10 years ago, and basically what happened was Hooters shamed the man bringing the lawsuit into dropping his lawsuit by putting out full page ads in newspapers of men wearing Hooters uniforms. Oh, okay.
I am aware of that, Pete. That's why I brought it up. I thought it was funny, but yes, I am aware of that.
Yeah.
Well, I think society shamed him as well because nobody wants to see that. I mean, that's just the bottom line. So.
Yeah, but he was making a political point. I don't think he actually wanted to work at Hooters. But but think about it. If you had separate uniforms for white and black employees, would that be a violation of the 1964 Civil Rights Act?
Oh, I think so. Yeah, absolutely. Because I think but there's a fundamental difference here that we have to understand between race and gender, and that's what we're having a culture war about right now that I think is ridiculous. I mean, I'm just going to say it. I think it's a ridiculous fight because I'm not. It's not that I'm not sympathetic to transgender people, and it's not that I don't understand that. But these issues, I think, for the most part, should be addressed privately. And if you have an issue with it, you always have the option of saying, "Hey, I'm not going to go to this business because of this policy. I'm not going to buy anything from them." I think there's a lot of overreach when it comes to a lot of these anti-discrimination laws in the workplace because they're being used for things they clearly were never intended to be used for. I just don't believe they were ever meant for this law to be used to say you can't have male and female uniforms and decide who gets to wear them.
Well, you're right. And the Supreme Court, and the Supreme Court actually agrees with you on that point. But what Gorsuch has said is that it doesn't matter what the original intent was, that what matters is what the law actually says. And so even your point is well taken.
Well, I don't agree with that either. See, that's a fundamental issue, and it surprises me, that's the interpretation because, I was always taught in history class, government class, social studies consistently, growing up as a child, that the entire point of the judiciary is to basically interpret the law so that they apply it the way that it was intended. It's not about the letter of the law; it's about the spirit of the law, and that's why we have courts. That's the only reason we have courts. But it seems more and more to me that's not what they do. There's this notion that as times change and culture changes, well, now we have to apply the law differently. I think that's garbage. That's just me.
Right. Well, that's the big difference between the textualists and the originalists on the court. And you have people. Gorsuch obviously identifies as a textualist. Some of the other conservative justices do as well. Elena Kagan, who's on the left, now identifies in some circumstances as a textualist. But other Supreme Court justices on the right, I believe Clarence Thomas, calls himself an originalist. Although, he does worry about the role of the letter of the law as well. Now, the thing with the left is that many of those left-leaning justices over the past century have said, yes, the spirit of the law, the living Constitution, but they don't mean the original intent. They mean given current circumstances, given current political mood. Yeah. That's a very different thing.
That's what I'm talking about. That's what I really disagree with and I think is wrong. I do believe that the letter of the law does, have relevance. I'm not saying it's irrelevant, but I'm saying if you can argue it either way, you need to go back to what did the framers of that law actually intend and rule in that regard. What issue were they trying to, address? What problem were they trying to solve? And that's what I think. That's what I think the courts are for. But I think the courts are ignoring that more and more and more.
Well, I just wanted to hit one last point before we move on, and we're going to have to skip over police reform because we don't have enough time. We've gone over on this segment, but the other cases had to do with gay men who had been fired from their jobs, ostensibly on the basis of their sexual orientation. Now, the courts actually didn't rule on that because that wasn't the question before them. The question was, is it illegal to fire somebody on the basis of sexual orientation? So they didn't have to adjudicate the facts. They just had to adjudicate the principle, if that makes sense. That's why all these cases were lumped together, because the Supreme Court is not ruling on 3 cases simultaneously. They're just being asked, what is the principle that courts have to rule by? Okay. So they ruled that you cannot fire somebody on the basis of sexual orientation because it intersects with sex. And okay, it kind of the same issue as the last one we talked about. But here's where it gets really interesting. In those cases, at least one of them, the person who was fired was accused of embezzlement and almost certainly was not fired because of sexual orientation. Not that it doesn't happen, but in this particular case, it looks like his lawyers are just throwing spaghetti against the wall, hoping that they could make it about sexual orientation so they could take the spotlight off of his embezzling of, I believe it was over $500,000. So that's just funny how that works out.
I guess he has a good lawyer. He's going for anything he possibly can to save his client. But I will say, Pete, don't you see that there's an irony here, in that it seems like in one circumstance the court is saying, well, you need to have a literal interpretation of the law when it comes to this circumstance, but in the other circumstance you're saying, no, don't use the literal language of the law. We're going to interpret this as applying to sex. And of course, sexual orientation does not apply to sex for the letter of the law. Sex is not about orientation. Sex is about being male or female. It is not, has nothing to do about your sexual orientation. That's not in the law. So what they're saying is they're sort of expanding the definition of sex to include your sexual orientation. And that's completely contrary to what we were just talking about, where they were saying, no, we have to take a literal interpretation of this uniform issue because this is what the law actually says. Right.
What Gorsuch said was, look, if a person is a man and he's in a relationship with a woman, that's okay. That he would not be fired for being heterosexual. But if he is a man or let's say it's a woman in a relationship with another woman, the difference is the sex of the employee, and therefore, even though it's not, sexual orientation itself is not protected, the fact that the employer is treating the employee differently on the basis of sex, and I understand it's maybe you could argue it's kind of a strained interpretation. But he contends, rightly or wrongly, that this is a literal interpretation of the law.
Yeah, I don't see that. I think that they're talking out of both ends of their mouth there. That's not, to me, that's not consistent. That's trying to have your cake and eat it too. I don't know any other way to put it. It just doesn't seem logically consistent to me.
Yeah, well, that's certainly the debate, and that's why Alito was so furious with the ruling.